name's Jay McDaniel. Thanks for joining us today. We're going to be discussing the concept of undue influence in trust and estates law. If you have any questions on this material after the podcast, you'll see my contact information and feel free to contact me. Specifically, we're looking today at the elements of an undue influence claim under New Jersey law, which is where I practice. Undue influence claims are often center stage in wills, trusts, and other estate disputes. First, let's clarify what undue influence is. It refers to the situation in which someone exerts such significant psychological influence over another person that they overcome their free will, and that person makes decisions, almost always about money or real estate, that they might not have made otherwise. You see undue influence claims when someone makes a will or a trust and disposes of their property while they're under the sway of somebody else. Now, in New Jersey, the Supreme Court has defined undue influence as the creation of a mental, moral, or physical exertion that destroys the free will of the person who made the will. People who make wills are referred to as testators. It prevents them from following their own mind. It's conduct that causes the testator to accept the domination and influence of someone else rather than following their own wishes. There are some general rules in proving undue influence and some special rules that can apply in particularly suspicious cases. Proving undue influence under New Jersey law involves several key elements. The plaintiff in a lawsuit challenging a will bears the burden of proof, as they do in most civil cases, but particularly suspicious circumstances can cause a court to apply a presumption of misconduct that shifts the burden of proof in an undue influence case to the person who is likely to be the wrongdoer. The proofs in an undue influence case will often go something like this. First, the plaintiff must show that the defendant, that's the person who's charged with undue influence, had a confidential or fiduciary relationship with the victim. Confidential relationship includes professional relationships like attorney and client, but it can also include a parent and child, particularly when the child is taking care of the parent or responsible for the parent's finances. The courts in New Jersey say that the confidential relationship exists where trust is reposed by reason of the testator's weakness or dependence, or where the parties occupied relations in which there is a reliance that is naturally inspired or in fact exists. Now, if there is a confidential relationship, the plaintiff must still show suspicious circumstances. What are suspicious circumstances? That varies from case to case, but if the person who benefits from the change in a will is also the executor, that may create a suspicious circumstance. Or if there's a professional conflict of interest, such as when an attorney becomes the beneficiary of a will that he prepared, that may create suspicious circumstances. In these cases of suspicious circumstances and the existence of a confidential relationship, the burden will often shift to the proponent of the will, that is, the person who's submitted the will for probate. The court can presume that there was undue influence unless that presumption is overcome by clear and convincing evidence that there was no undue influence. The court may still require the person raising the undue influence to show that the testator was susceptible to pressure, and such factors as the victim's age, the victim's illness, his or her mental ability, and isolation from family and friends can all be a relevant factor. Courts also look at what they describe as an unnatural disposition. Unnatural disposition means some kind of result that's out of character for the person making the decision. An example would be changing a will to leave the entire estate to a newly made friend or to a caregiver, instead of leaving the estate to family members. Undue influence claims are easy to make, but they can also be difficult to prove. They also can be extremely challenging to the family member who is appointed as an executor or trustee by a relative who relied on them for their care in later years. These are difficult, emotional cases. If you think someone was unduly influenced, or if you are the subject of an undue influence claim, feel free to use the contact information below to get in touch with me and discuss the issue. It's important to get legal advice because if the court finds that a will or trust has been created through undue influence, then it can validate the will or the trust in its entirety or in part. It can also charge a fiduciary for legal fees, and it can force a forfeiture of the executor's commissions that a fiduciary often receives for being responsible for the probate of a will. These are all serious issues. Thanks for listening.